Hello, welcome to the show. My name is Jacob Davidson. I'm a legal layman in North Texas, and this is a show where I learn the law and I try to educate while I learn the law. And this is the second, most likely last video I'm going to make on the Ken Paxton impeachment, particularly in relations to the actual impeachment itself, because hopefully I will be done with the impeachment hearing video today. I don't want to be stuck on this one for too long. So yeah, I think I won't be doing too much of an introduction on it. And yeah, I'm gonna probably jump right into it. Just gotta find my place. I goofed earlier and I forgot to post the links before I went to sleep, so the link just got out for basically everyone. So yeah, that's a bit of an embarrassment, but you know what? It's a gaffe. I'll get over it. Just gonna put everything up in their way. I also hopefully fixed my whole tea problem that I was having. With that said, there we go. All right.
No, that was a hearing.
So the questions leading up to where we are now, I believe, were basically, did the House ask or investigate the matters? And the House answered, or the committee answered, we hired a team of investigators that we trusted. And then they asked, did the House at all talk to any of the witnesses that brought these charges to them? And they said the investigators talked to them. And then they asked, anybody of the full House ever get a chance to speak to these people? Once again, the investigators. And then they asked if these things were made public these findings were made public for the people or for the House. Only some of it was. There was some confidential aspect to the information. And so we continue.
Hearing in which the attorneys and the investigators that were hired by the General Investigating Committee provided a detailed and
Oh crap, it's an ad.
specific summary of all the evidence from their 15 interviews of witnesses and the culmination of reading pleadings and documents and other information that they gathered.
Chairman Murr, has any member of this body heard directly from a witness that was involved in this investigation?
I'm not advised of that because there's no restriction for any member here to reach out to any participant in the whistleblower allegations and the lawsuit. It's been going on literally for more than 2 years. So I'm not advised.
Have you made any opportunity through the auspices of your committee for the witnesses to engage with the members?
That is the purpose of the committee, but if members wanted to engage directly with that, I don't think there's any restriction, but I'm not advised if that has occurred.
So there were no restrictions, but your committee chose not to make an opportunity for the members to talk to witnesses, is that correct?
Again, I will point out that the construction of the House rules for almost a decade, as well as the government code, establish investigating authority with the General Investigating Committee. And so that is the workhorse for your investigation purposes.
But is it not correct to say that your committee could have made witnesses available for the membership to speak with and ask questions?
So I will point out, whenever you bring that up, that let's start first with the whistleblower lawsuit. Whistleblower lawsuit involved 4 individuals who were terminated from their employment because they feel like they did the right thing. They identified what they realized was criminal wrongdoing. They went to law enforcement and reported it. They reported that to HR to some extent, but were terminated, were fired from their jobs. Now, other people that learned about that, they went ahead and resigned because they said, I can't work in that environment. All said, we learned, and you're aware, that of 15 witness interviews, all but one said that they had grave concerns for retaliation from Mr. Paxton on a professional basis, that it might affect their livelihoods, their ability to keep or get a job, similar with their spouses. So they were very concerned about that. This work, and I'll finish, this work was done with the fact that some of those folks that agreed to sit down or were subpoenaed and sat down and did interviews did so while they said, I will certainly appear at a trial and under oath provide testimony.
Mr. Poopy Butthole, I love you. Go fuck yourself.
I am concerned about my name being out there. I am concerned about unnecessary exposure when I'm living in a world of a little fear and retaliation every day.
Chairman Murray, you and I heard the presentation by Representative Johnson. And in that presentation, she said that all roads lead to Nate Paul. Do you remember her saying that?
I heard that.
Did the committee compel any testimony from Nate Paul?
The committee began its work by reaching out to the participants in the whistleblower lawsuit, and from there went to witnesses identified by those folks. So those would be participants who were not in the whistleblower lawsuit. The committee has not reached out.
Barnes changed your mind? He thinks that Paxton's being railroaded? I already have a couple problems with the whole impeachment process, but I can't quite put a finger on a couple of them. I mostly don't get the Speaker of the House being like, not answering the first question he was asked, and that was, do we vote on the article separately or all in one? And it was like, they'll present it and then tell you the rules. And it's like, that's very helpful, Speaker. Thank you. And yeah, I kind of have a problem with the committee basing their whole decision on the opinions of a third-party investigator. They should have used that supplementally and not as the only means of which they came to their conclusion. That's probably a big problem. But yeah. Wait a minute, I had a...
To be participants who were not in the whistleblower lawsuit.
Oh yeah, I also want to say, I think it's a fair enough thing if a person claims that they're afraid of backlash to an official being protected. I think that's kind of in your normal court case anyway, where witnesses are shielded from being revealed until after they testify.
The committee has not reached out to Mr. Paul.
Did the committee subpoena any?
If Paul is the end of all these roads, why not go talk to him? Like, what's that? That's what the fuck? I mean, shit. Senate here, or the House here, has the power to compel him.
Documents from Nate Paul.
The committee has not yet subpoenaed any documents from Nate Paul.
Thank you, Mr. Chairman.
Mr. Tyndall, for what purpose?
Thank you, Mr. Speaker. Will the gentleman yield for questions?
The gentleman yield for questions.
I yield.
Thank you, Chairman. How many investigators were there?
Hired a total of 2 investigators, and that was laid out. I think you heard that from Chairman Longoria
Right.
as he presented.
And so essentially, but there were 5 people that were hired. Was it 5 or 6 that were hired?
6.
Okay. So I misunderstood. I thought there was 5. So how were they chosen?
Parents, summer can only mean
The active goal was to look for folks that had experience, especially in public integrity matters, white-collar crime, and preferred to have experience gathering information and with a keen eye of whether or not any criminal conduct occurred, because that was the basis of the allegations in the whistleblower lawsuit.
So we're all, I will accidentally say 5 because that's what I have written in here, but were they all from the same city or county?
No.
Had they all worked in Harris County in the past?
To my knowledge, off and on, they may have, but not all of them at the same time.
Would
I'm
you be
not aware.
surprised if I told you that of the 5 that I was aware of, all 5 of them worked in Harris County with the vice chair of the committee that you're the chair of that initiated this resolution? Would you be surprised by that?
I also wouldn't be surprised, as you have Chairman Dutton behind you, that Harris County has over 2 million people and a lot more attorneys and investigators than many other jurisdictions around the state of Texas.
Would you be surprised to find out that 3 of those 5 were fired by their district attorney at one point?
I believe that you will also learn that they have experience that spans decades and oftentimes worked in environments that swayed and ebbed and flowed pursuant to elected officials.
Are you aware that 3?
I get the purpose of this guy here. I wonder how it goes.
Three of the attorneys vote in Democrat primaries, and one of them switched to be a Democrat in primaries in 2020.
I do not care how they voted in a primary or an election in Harris County. What I do care about is their work product, their ability to conduct themselves professionally, and to provide an opportunity to gather detailed information on behalf of the General Investigating Committee.
Do you see how it could appear or it could be perceived by anyone in the building or outside the building when they're Democrats? Could you see how it could appear that it's politically motivated investigation?
No,
on their behalf.
I could also see that multiple of those persons that we hired to work for us also worked in the U.S. Attorney's Office for a Republican appointee from a Republican president. So, no, I do not see that appearance.
I believe perception is truth to the person that perceives. So if someone perceives something, it's truth to them whether.
Oh my God, this guy. Perception is truth. He dropped that. He dropped my hated thing in the middle of it. Nah.
Whether it's truth or not. And so I think the hiring and where they're from and the fact that they were fired and that they're Democrats could create the perception that this was politically motivated.
I mean, ultimately, he's just saying this, I guess, to put it on the record. But, like, this doesn't ultimately stop or prevent what happened. It wouldn't have even, in foresight, stopped anything.
So
I disagree completely with you.
So my understanding is that they did not reach out to anyone in Attorney General Ken Paxton's office, not from the highest levels or the lowest levels during their investigation. Is that correct?
So as I explained earlier, and you've heard other explanations, in February, Mr. Paxton and members of his staff appeared before the Appropriations Subcommittee and requested $3.3 million to fund a settlement. But declined to provide any additional information. Now, I do know, and we've heard explanation, that a almost 400-page document was produced on their website in defense of that lawsuit, and that's where things were.
So, so none of them were talked to since March when this investigation was initiated?
No, sir. We began with the whistleblowers to learn more information about the claims that they had made in their lawsuit.
So we've had a couple of impeachment proceedings over the history of Texas, and in both of those, the opposing party was talked to. As a matter of fact, let's just talk 1975. In 1975, they had 70 to 90 hours of open testimony and meetings. You had 1 day. And those hours that were given, anyone could go watch them and listen to them, and both sides were afforded the opportunity to say their side. In the 1917 case, I believe, they were on the floor in a committee of the whole, and the chairman was asked questions by committee members. The reason I'm saying all this is there's no testimony. As a matter of fact, the AG's office tried to go to your committee on the 24th and were not allowed. That's concerning for me. Can you explain why Attorney General Paxton's office was not contacted, not allowed to testify on their own behalf?
You've got a lot in your questions, so if you'll give me a little latitude here to try to address several different topics. So you talk about 1917, you talk about 1975. In 1917, it involved a recently resigned governor who's no longer in office. In 1975, it involved a district judge from a single county in the state of Texas. Those both involved an era in which didn't contain current House rules that were designed to put the power of adopting articles of impeachment into a committee such as general investigating. So therefore you saw, as you mentioned, a committee of the whole, and I explained that in a memorandum that we provided to this body yesterday. Comparatively to a recently resigned governor or a district judge in a single county in the state of Texas, we are talking about an accused person that is currently in the highest elected office for an attorney in the state of Texas. He sits in that office and can use the significant powers granted to the Attorney General to do a lot of different things. And that makes it very concerning whenever you're going through this process. As you've seen in the last few days, we have seen literally the Attorney General use his agency to lobby this legislature. We have seen the Attorney General call people on the floor.
When you say that,
lobby.
you're making accusations. I hadn't heard that. I'm not saying it's not true, but you're levying that like that is actual truth. Did he call your office?
No, he did not call my office,
Okay.
but I'm familiar with the fact that there are members on this floor that have received telephone calls from the Attorney General.
So are you aware
just
that,
in the last few days.
Are you aware that in 1975, they didn't give us 48 hours to decide. They gave us both sides of the story, and they gave 3 weeks to decide. Why are we given 48 hours to make this decision and be here today?
Probably the answer will end up being those were under the House committee, not the General Investigation Committee. That's probably where that answer is going to go.
I feel like it's rushed. I perceive that it could be political weaponization. And I'm asking, why are we given 48 hours when in 1975 they were given 3 weeks with both sides of the story?
You know, if you'll look at the investigatory process in 1975, it lasted approximately 50, 60 days. And so I appreciate the fact that for you it seems sudden and rushed, but for the purposes of the committee, we have been working on this since February, whenever this legislature was asked to spend taxpayer dollars to fund the settlement of a whistleblower lawsuit.
Why didn't we know about that till now?
And this committee's been working since March, and the culmination of our work was placed and downloaded into a very long and lengthy, detailed public meeting, which the video is publicly available and the transcript's publicly available.
So why weren't we, as members, not apprised of what was being investigated for 2 months when historically the members know? The public knows.
As you are well aware, the House rules, committee rules, and actually sections of the government code place the authority to do investigation with the General Investigating Committee. And in some instances, as you're well aware, that is done in the confidence both to protect those that raise concerns, protect the process for as witnesses go, and to protect the end result, which is providing evidence and information.
So let's compare two investigations without names. There was matter A and B. In the matter that we disposed of earlier this month, the opposing party, the party that was being blamed for something, was asked to testify, as were the people in and around this individual's office. So both sides came and testified to you, or were given the opportunity. Can you tell us why in this case they weren't allowed to, but in the other case that was disposed of this same month, the other case they were allowed to and asked to?
I understand, and respectfully, you're comparing an apple and an orange. So when you talk about matter B, talk about a process that involved written complaints of workplace misconduct. That is addressed in the housekeeping resolution, in the House rules, and the committee rules. And it's handled in a very special and specific way. And that is not necessarily the same framework in which we're talking about the articles that we have before us today, which involve also committee functions, but they can be derived in the government code as well as our House rules, but in different sections.
So I believe that they're both also similar in the fact that we removed a duly elected state official from their seat, and this is potentially what's going to happen to this individual. So I see large similarities. A couple of other small questions that I want to close out with is, are you aware that both Trump and Cruz made statements about this today? Are you aware that they both did?
I'm not advised.
Okay, they both did, and I'll spare the body some of the statements that Trump made because I don't want to engage in personalities. But Ted Cruz, are you aware that he's a constitutional attorney?
I'm not advised.
He is, and he basically talks about the swamp once this individual moved out of their office, and he's showing full support for the Attorney General. I'm just wondering if you have any statement about that when he's actually seen recently one of the most egregious impeachments in the history of the United States, and he's speaking about it. Do you have any statement about that?
I would only direct he and members of the public to go and watch the video of our investigators and attorneys providing detailed information to the committee and/or read the transcript that's publicly available.
So my last question is, how much did these investigations cost us? Because we were never made aware. We weren't asked about it. Just can you give us an estimation of what was spent to conduct these investigations?
I am not advised of that.
Okay, thank you for being respectful, and I appreciate you, sir.
Oh, I hate these ads.
The time for
Being respectful.
statements has closed. Chair recognizes Mr. Smithy. Open statement.
And I appreciate you, sir.
The time for proponents' open statements has closed. Chair recognizes Mr. Smithy. We will now hear opening statements from the opponents of the resolution.
Mr. Speaker, parliamentary inquiry.
Please state your inquiry.
It was laid out that the opening remarks were only going to be 30 minutes. They went significantly longer than that. Are we not going to have the opportunity in turn for more questions?
The chair stated that the opening statements would not impact the time allowed for questions, and they did not. The full 20 minutes was allowed for questions.
There's no extension.
Yeah, but that wasn't the question. That wasn't... He didn't ask if the proponents or opponents would have full question time. He was asking if they would have full presentation time, because the opening statements for the proponents of the resolution had like basically an hour or two, an hour and a half. God, the state guy. How does he?
And the hour taken in opening testimony will count against them in general debate. Mr. Dutton, for what purpose?
There we go. It's mildly addressed.
I'd like to ask the representative questions.
Mr. Smithy, or
Mr. Smithy.
not at this time. Mr. Smithy is going to begin his opening remarks.
Okay.
Under the previously adopted resolution, Mr. Smithy has 30 minutes of uninterrupted remarks. Chair recognizes Mr. Smithy.
Thank you, Mr.
Yeah, but if he doesn't, he has only 30 minutes. I mean, it counts against the proponents of the resolution to have the time count against them, but like, if he only has 30 minutes and they took up an hour, that's not really fair to him or his side.
Speaker and members, and I assure you I'm not going to take 30 minutes. But let me tell you, first of all, I'm not here today to tell you that General Paxton should not be impeached. That's not why I'm here. Bottom line is I don't know whether he should or not because I don't have the evidence before me to make that determination. All I'm telling you is this House cannot legitimately and in good faith and under the rule of law impeach General Paxton today on the record that it has before it. I'm not here to defend Ken Paxton. That's not my job. I'll leave that to someone else. But I'm here to defend two things that are precious to me. One is the rule of law, and the other is the integrity of the Texas House of Representatives, of which I've given a good part, the best part of my adult life. What we're doing here today is very important. You've heard that. It's a very sober and somber experience and process, and it should be. And there's three reasons for that. You've heard, and I've heard conversation on the floor from members, and we've heard a bit of this today. This is only like a grand jury. We don't need to adjudicate guilt or innocence, and that's true. But this House, historically, and with its president, has always applied a higher standard to these proceedings than it has to a typical grand jury. The House has always been concerned about due process and constitutional rights, and above all, the fairness that goes with a process such as this. And there are three reasons for that. Three very, in my opinion, very compelling reasons. The first is that our actions today have an immediate consequence. If we vote to impeach today, as soon as we do that, then General Paxton will be automatically relieved of his duties. He will no longer function as Attorney General of the state of Texas. It's what I call the hang 'em now and judge 'em later policy. The consequences of our impeachment is that he will be removed from the responsibilities of his office, even though his guilt or innocence has not yet been adjudicated. The second reason that the House has always insisted on a complete record, which we have no record before us, no record, no report before us. But the second reason is it is our responsibility to provide a record upon which the Senate can make its adjudication of guilt or innocence. Yes, they will have a trial there, but the basis for that trial is the record that we prepare here in the House, and there is no record to send to the Senate. The third reason, and to me this is extremely important, and that is just as we should be but are not looking at precedents of the Texas House, future legislatures should and probably will be looking at this precedent. We do not need to be relaxing the due process and the fairness concerns. When we go home, these are important. When we go home, we'll have to defend, each one of us as members will have to defend not only the final result that we reach today and the way we vote, but we'll also have to defend the process by which this determination was made. And members of the House, to me, this process is indefensible. It's absolutely indefensible. Not to be critical of anyone, but when you look at the precedent precedent is so important. I recently argued a case in the Supreme Court of Texas, and our argument was that precedent matters. And as the court pointed out in both its majority and concurring opinions, it said that precedent is important for two reasons. One is because of predictability, and the other is stability. Stability and predictability. That's important in the law, and it's important in House and Senate procedure. Now, as we approach this today, we basically have two prior impeachment proceedings and one that began as an impeachment proceeding, actually two that began, that are instructive for us. The first one has been mentioned. It's the 1917 impeachment of Governor Ferguson. And in that, there are several things that are very instructive historically that occurred in that particular impeachment. First, the House has always adopted rules in advance and they have always authorized the investigation into the public official. That way it is done out in public. It is done with the antiseptic of sunlight. This was not done that way, but rules are adopted in advance. We received the small rules that we have less than a few hours ago. The rules were made up as we went in this process, and that's not the way it should be. One of the things that the rules have always required, since 1917, again in 1929 in the aborted Robinson Land Commissioner impeachment, and again in 1975 in the Carrillo impeachment, one thing that the legislature has always insisted on is that the proceedings be done in public, that the public have access, the public have knowledge. Now, I think it's ironic that we're conducting this hearing today, we're doing this determination today during a holiday weekend when most of our constituents are busy doing what you should be doing on Memorial Day weekend, and that's memorializing those who've given all for this country, or else they're spending time with their family. They're not concerned about this. It's like dumping information late on a Friday afternoon of a news cycle. We should be doing this in the open daylight. We should be doing it not with 48 hours notice. We actually had less than 24 hours notice that we were going to do this today. We should be doing this with full notice and full opportunity for the public to participate, not directly in the House chamber, but to watch and to attend if they choose to do that. And we shouldn't do it on a holiday weekend. We've always had the public involved throughout the process, in the hearings, the committee hearings, and all throughout the process. Another thing that they did in 1917 that they've done continuously since then, they have always said that the accused, in this case General Paxton, had the right to be represented by counsel during the proceedings. There is no indication in the record that General Paxton was ever afforded that opportunity. Number three, since 1917 and all of the intervening impeachment proceedings since then, counsel for the accused has been permitted the opportunity to cross-examine the witnesses. And that never occurred because no witnesses were ever examined in this case. Not one witness was ever examined by the committee. Not one fact witness who knew anything about anything was examined in the committee. Do you know how it worked? They had these investigators, these kind of anonymous we know their names, we know a little bit about them. These investigators, they came and spoke to the committee. From the record that I've been able to uncover, and I confirmed this with Mr. Murr, they were not even required to sign witness affirmation statements before the committee. Now, we require witness affirmation statements when somebody testifies on behalf of a local or an uncontested bill. But we didn't require it in this instance. And what you've heard and what's in this report is not one shred of evidence. You're all familiar with the term hearsay, but what you have in this case is triple hearsay in most cases. It is hearsay within hearsay within hearsay. No prosecutor would ever try to get a grand jury indictment based solely on hearsay within hearsay within hearsay. No jury would ever convict. No civil jury could ever award judgment or enter a verdict based on the evidence that's before this House today. And so that's another thing. There was no ability for counsel for Mr. Paxton to cross-examine. There was no opportunity for anyone to cross-examine. In 1917, the House determined that the impeachment proceeding would be conducted as a trial with all of the due process requirements in place normally given. Now, that's not the case with grand jury proceedings. But the House was convinced that it wanted to go the extra mile in providing fairness and notice. And so it was conducted as a trial. And one other thing that applies to every impeachment that has ever been done in the Texas House of Representatives has been that all evidence must meet the standard required under the Texas Rules of Evidence. And I will tell you, there is not one word, not one sentence in the testimony before you that would be admissible in any Texas court of law under the Texas Rules of Evidence. It is hearsay, within hearsay, within hearsay. Here's something else is troubling. In a court of law, some of you have testified. You are sworn under oath. You testify under oath that on your honor that you will tell the whole truth and nothing but the truth, so help your God, okay? And if you don't do that, and it is later found out, you are subject to charges for perjury. And because of that limitation, most people, not all people, but most people tell the truth when they're giving official testimony. It concerns me, and I hope it concerns you, that in this case, in this impeachment proceeding, not one witness was put under oath. Not the investigators who testified what person A testified that person B told them. Person A was never put under oath. Person B was never put under oath. No one was put under oath. And so you have all these things that amount to accusations, but not testimony and certainly not evidence. And that concerns me. It concerns me a lot because today it could be General Paxton, tomorrow it could be you, and the next day it could be me. Our fundamental rights of due process are so important to every one of us, and they're important to preserving the republic that we have. Now, one other thing, as I said, the testimony has always, in the Texas House, any testimony used to convict someone, to impeach someone, has always been under oath with penalty of perjury. And another thing that has always been done, and we're breaking precedent in that regard, is counsel for the accused has always been permitted to attend within the House chamber, the open chamber of the House, to represent the accused. Members of the House have always been given the opportunity, even though they will not serve on the committee, they have been given the opportunity to submit written questions to be asked of the witnesses. That never, ever occurred in this case. So in 1917, you had rules adopted in advance, so everybody knew what the rules were. You had the public involved in the proceedings. You had the accused with the right to be represented by counsel. You had the right to cross-examination. It was conducted like a trial. Evidence was admissible, and all testimony was given under oath. That was what due process and fairness looked like in the Texas House of Representatives in 1917. And in my opinion, that's what due process and fairness should still look like today, not only in the Texas House of Representatives, but everywhere. Let's talk a minute about the 1975 impeachment of proceeding involving Judge O.P. Carrillo. Two members of our House were present for that. Speaker Craddock and Representative Thompson were both present for that. The author, many of you know, was Terry Canales Sr., who was, and I believe Mr. Bryant was present at that time too. But Terry Canales Sr. was the author of the impeachment resolution. But it's very instructive what happened in 1975, because at the beginning of the proceeding, Judge Carrillo was notified that there was an impeachment proceeding investigation pending. And the House Select Committee sent this notice directly to Judge Carrillo by telegram. They said, you are invited to be present in person or by an attorney. Any evidence you care to present bearing on the inquiry will be welcome. The principal function of this committee is to develop facts, and your assistance in this endeavor will be appreciated. And so, the accused was told, if you've got any evidence, anything you want us to know, anything you want us that might be used to exculpate your guilt in this case, we want to see it because we want to be fair and we want due process. And so that's what fairness, that's what due process looked like in the Texas House in 1975, and that's the way it should still look. We've learned from the record and from talking to some of the committee members that General Paxton was never notified of these proceedings. He was never invited, much less allowed, to provide any material, any evidence, or any testimony that might in any way be exculpatory toward his guilt. That is not fairness. That is not due process. That is not the way that things should be done. A couple of other words about the Carrillo impeachment proceeding. Their members then were allowed to submit questions. All members were involved, were allowed to submit questions to all of the witnesses. They actually had witnesses in that case. There were 32 witnesses, as a matter of fact. All witnesses who testified were testifying based on personal knowledge, not one in this case based on personal knowledge. And they testified under oath for approximately 70 hours of testimony before the House committee that considered impeachment in that situation. They accumulated 15 volumes of testimony. They had 170 documents in evidence. What we have is we don't have a report. We've always had a report. There's no report. There is a transcript, and it is 170 pages, somewhere in that range. It's thin. It's just 170 pages. Not one document. In that case, 170 documents were submitted as part of the report in evidence. In this case, although multiple documents are referred to as being highly incriminatory to General Paxton, are referred to in the report, not one of those documents has been provided the House, and not one is attached to any report that's been provided to the House. And so you have that matter of due process. It's like in 1975, the House embarked on a slow and deliberative process. They invited the accused to attend and present any evidence that might bear on his innocence. And they gave the opportunity for cross-examination by the counsel for the accused. And that was what due process and fairness looked like in 1975 in the Texas House, and it's what it should look like here today. You know, members, I'm aware that there are certain members in this House, certain people in this chamber, who want to get rid of General Paxton for whatever reason in the worst possible way. And I'm here to tell you that what we are doing is absolutely the worst possible way. There's a right way to do things, and there's a wrong way to do things. If you want to do this the right way, what we should do is vote no on the resolution today. If you want to, we can come back as a committee and do this the right way. And the right way would be to ask we have subpoena power. We can compel these witnesses who supposedly have factual knowledge, we can compel them to come in, testify under oath with opportunity for cross-examination. We can notify the Attorney General. We can subpoena documents. We can allow the Attorney General to appear and present any exculpatory material that he might have, and we can do it the right way. And the committee can do that after we have adjourned the session. We can be called back for a one-day hearing to consider a real record that gives us a sufficient basis. You've heard this compared to a grand jury proceeding, and in some ways it's like a grand jury proceeding, and in other ways it is not. But I can tell you this, that no grand jury can legitimately indict any individual, any potential criminal defendant without evidence. You can't indict without evidence, period. And what you're being asked to do today is to impeach without evidence. It is all rumor. It is all innuendo. It is all speculation. It is all things that we may speculate to be true, but we don't have what is defined or what qualifies as evidence in any court at law, not only in Texas, not only in the United States, but in most developed countries in the world. And so I would just say this, that I want to be, if I'm ever going to be in part of any impeachment proceeding that actually results in the impeachment of an officer, I don't want it to look like a Saturday mob out for an afternoon lynching. I want it to look like a clear, deliberative, somber, and sober exercise in the quasi-judicial function that the Constitution gives us the right to engage in. Members, thank you so much for your attention today. I appreciate the time you've given me.
The chair recognizes Mr. Tinderholt. The chair advises our guests under the rules of the House, demonstrations or outbursts by visitors in the gallery are strictly prohibited. The chair recognizes Mr. Tinderholt.
Thank you, Mr. Speaker. Members, it's a sad day for our chamber. We often talk in this building about transparency in everything that we do because our voters deserve that. I feel like there wasn't a lot of transparency for the entire 2 months of this. The Texas House is taking a practice that's only been used twice in Texas history and deviating severely from that practice instead of carefully deliberating on this issue as those who came before us. We've decided our chamber is nothing more than a weapon to wield against political opponents. This body is afforded more time for debating tampon tax relief than we've given to deciding whether to impeach the highest law enforcement officer in our state. Let me tell you, I don't think today is about whether there's guilt or innocence. It's about the process. At the beginning of this session, Speaker Phelan ruled this chamber wasn't allowed to debate legislation or rules that could be seen as using it for political purposes. This is political purposes. Now our Attorney General, who was strongly reelected by the voters in both our primary and general election, might be impeached today because he's a political opponent of the opposing party. Members, I'm deeply concerned by the way this investigation is handled. The current House is totally breaking with precedent for considering an impeachment according to the last 2 ones we've done in history. The General Investigating Committee never interviewed the Attorney General, never interviewed top staff, or anybody else, especially when they showed up on the 24th. Why? I can't answer that question, but I can say that it creates horrible perception. According to Chairman Murr, this matter has been under investigation for approximately 2 months, and records show that to be true. But our chamber was never informed as to what was being investigated. Does pushing this through so quickly in the late hours of session seem ethical, thoughtful, or responsible? I say no. I've heard many of you say in the past you don't want Austin to look like D.C. The sad reality is that Adam Schiff and Nancy Pelosi put more time and deliberation into the impeachment of Donald Trump than the Texas House has done in the last week regarding this matter. For my Republican colleagues, I want to let you know that I'm sorry that you're being used like this. I'm sorry you're being forced to swallow a long list of policy that was killed this chamber and then be used to impeach one of the most popular Republicans in our state. Remember, we're not talking about whether there's guilt or innocence. We're talking about process. The same voters that sent each of us here elected him as our Attorney General. Some don't like that. But to make a last-minute decision to impeach him without due process or transparency is imprudent at best and a gross abuse of power at worst. This session, the General Investigating Committee has investigated 2 matters that we know of. In one, the respondent was afforded due process to respond to the allegations while the committee was convened in an executive session. On May 24th, Chris Hilton, the chief of general litigation at the OAG, made an appearance at the General Investigating Committee and attempted to register as a resource witness in defense of Paxton. He was denied by the committee. According to the OAG, the General Litigation Division has a broad practice that includes defending state agencies elected and appointed officials, and state officials and employees in civil litigation. That's their job. They showed up to do it, and they weren't afforded the opportunity. This is one-sided. In 1975, it was the last time the legislature initiated impeachment proceedings against any official. After a single member filed a resolution recommending impeachment, a select committee on impeachment was appointed to investigate. Across almost 2 months, 21 committee meetings, and 90 hours of consideration, the committee interviewed 32 witnesses with direct insight totaling 70 hours of public testimony. The findings of the committee, as well as the transcripts of public testimony, were combined into 16 volumes and distributed to members 3 weeks prior to floor consideration of articles of impeachment, and we have 48. In our case, well, think about that for a moment. We have 48 hours after everything was secret except one meeting. In our case, the General Investigating Committee called their own investigators as witnesses in the single public hearing regarding impeachment. Instead of questioning the witnesses in public hearing, the committee allowed the investigators to summarize and potentially editorialize their findings. Is this really what we've come to? If you think this is how we best serve Texans, you're gravely mistaken. When you vote today, don't listen to bullies inside or outside this building that try to intimidate you into submission. You're better than that. I know you all. This is wrong. You know it. Your voters know it. When you go home, don't end our session this way. Don't tarnish this institution. Don't cheapen the act of impeachment. Don't undermine the will of the voters. Don't give Democrats another victory handed to them on a silver platter. There's a better way. And today, that better way includes voting no to these impeachment articles. Thank you.
The chair recognizes Mr. Harrison.
Thank you, Mr. Speaker, members. I rise today in opposition to this resolution with a heavy heart, not just because of the seriousness of the allegations, and they are serious, but because the process, if it can be called that, which led us here. The allegations against Attorney General Paxton are extraordinarily concerning. However, I am equally, if not more, concerned with ensuring that the Texas House is not using the levers of power to criminalize opposition. Whether that is the true intent of today's proceedings or not, it will be forever impossible to divorce what may be virtuous motives from what we are witnessing today, which bears all of the hallmarks of the weaponization of government power to target a political opponent. Now, let me be clear. Texans should demand the highest standards of ethical behavior, propriety, and adherence to just laws from those in high office. It is very possible that standard has not been met by the current Attorney General. He may well have committed acts that are preclusive of being the state's top law enforcement officer.
Yeah, I think I still am Poopy Butthole. I think that still is a thing. I've been sitting through a bunch of people talk about things. Very nice. Very nice.
For example, what is not in dispute is that 8 of his most senior officials left amid troubling circumstances, and that he, for whatever reason, chose to cut a settlement with them that did, in fact, expose my constituents and yours to paying millions of dollars. This is, of course, a matter that, as fiduciaries of tax dollars, we should take seriously. In fact, and as an aside, I wish this body demonstrated the same level of concern for every single line item in this budget that was $3 million or more. If a public official is going to come under criminal scrutiny or have allegations raised against them that rise to the level of impeachment, the impeachment proceedings themselves must be unimpeachable. That has not happened here. When the stakes are this high, optics matter, perception matters, process matters. Less than 48 hours ago, and with no warning, we had a resolution containing 20 articles of impeachment quite literally dropped on our desks, along with nothing more than the transcript of one single public hearing. Most of these allegations have been litigated in the criminal justice system for many years.
Hey, Poopy Butthole, could you link me the Barnes video that convinced you that maybe this might be a sham? I want to be able to watch it whenever I work.
And yet not a shred of anything closely approximating new and sufficient evidence has been presented to this body. At most, the investigation has lasted 8 weeks, and it was kept secret. There was no impeachment committee impaneled, no testimony under oath, no sworn declarations, and when the body was told of this, literally hours ago, not one single question directed to the Speaker was met with an answer that inspires any confidence in this process whatsoever. We were given woefully insufficient time to consider all 20 allegations before being asked to take a vote that, if passes, would immediately suspend from office a very recently re-elected Attorney General who has, without a doubt, proven time and time again that he was, in fact, up to the most important task of our time, and that is fighting against the out-of-control federal government which seeks to destroy our rights, our freedoms, our liberties, our state sovereignty, and our Constitution on a daily basis. The questions before us today, colleagues, should be left before the courts and the voters. Finally, impeachments are not primarily about the guilt or innocence of the accused, but rather about protecting the integrity of the state and of our cherished institutions. Those are the things that will outlive us and that will govern our children. The actions we take while seated in these chairs will determine if the next generation inherits a free Texas where individual liberty and due process protect them from would-be tyrants, or a Texas where the ruling elite govern by edict and wield their power to criminalize, punish, and silence political opposition. I am opposed to this resolution, not because I am convinced of the Attorney General's innocence, but because of the leadership of this body made no legitimate attempt to adequately document his guilt, nor demonstrate to my satisfaction that this is anything other than a sham railroading of a political enemy. Thank you.
Members of the chair will now recognize members who have questions for the opponents who made opening statements. Mr. Dutton, for what purpose?
I'd like to ask somebody a question. I'm not sure who it is.
At this point in time, Mr. Dutton, you can ask Mr. Smithy, Mr. Chenderholt, or Mr. Harrison.
I don't get to ask Mr. Murr a question?
That was the previous round of questions, Mr. Dutton. This right now is for questions of those who made opening statements in opposition to the matter before the House.
I have no questions for either of them.
Mr. Schottstein, for what purpose?
Would Mr. Smithy...
Good God, the guy just wants to ask a simple question. I want to know his question too. Hold on, I'm trying to find. Oh, God damn it. The stream.
Yield for some questions?
The chair recognizes Mr. Smithy.
Yes, Your Honor.
Mr. Smithy, I think you and I both share a deep respect for Chairman Murr as well as this committee. I think our concerns are more so in the process of this. And do you believe that it would be a better route if we were able to have more than 48 hours to actually sit on this information and go through the evidence and make a deliberative decision?
Yes, and let me echo what you said about Chairman Murr. I will say this. I met with Chairman Murr twice at length in the last 2 days. He answered every question that I had for him. He answered it honestly and openly, and I appreciate that. I appreciate the time and the effort that not only Mr. Murr and the other members of the committee have given this process. Nothing that I said was meant to be disrespectful to them, they're all my friends. But I would have, and I apologize to them at this point for not bringing these concerns sooner, but honestly, I couldn't because I didn't know this was going on until Tuesday night. And this has kind of unfolded this week. And so what I wish we could have done was discuss this earlier and possibly brought some of these deficiencies in the process to light earlier in the process so that the investigation and the proceeding could be conducted fairly and in accordance with House precedent.
I agree with you wholeheartedly. I would add, too, you know, don't you believe that it would have been better if we could get testimony that was sworn under oath from these witnesses?
I think that's incredibly important for several reasons. Many people will say one thing when they're not under oath, but they say something else when they're under oath. Ask any prosecutor, ask any lawyer who's interviewed a witness who wasn't under oath. They get under oath and they say something different because all at once they realize the gravity and the meaning of what they're saying and the consequences for not telling the truth.
I agree with you wholeheartedly. And, you know, looking at the testimony, I appreciate the work that the committee did. My question is, you know, why have we not been given access to the same evidence that the witnesses are talking about? Do you believe that we would be able to make a more definitive decision as a body if we had the time and if we were given the actual?
I just want to let everybody know very quickly, a very sudden warning. I just heard lightning outside. If I suddenly stop streaming, it's probably because the power went out. And if I come back, I'll try to set it back up as quickly as possible. But if I stop streaming and I'm done in the middle of this, everything went to shit and the power went out. So, you know, there's that.
Evidence that is spoken about in the testimony as well as in the transcript.
That's absolutely right. Direct testimony is always the most reliable and reasonable way to get to the truth. When testimony becomes secondhand or thirdhand, it becomes much less reliable, much less.
I am actually curious about that whole drunken date thing. That's a bit of a curiosity. That kind of got swept under the rug pretty quickly.
Accurate. And I don't feel comfortable making a monumental decision as impeachment would be based on what is essentially third-hand testimony of an investigator having talked to a witness in the OAG who heard this from another employee of OAG. I don't feel comfortable on that at that level of evidence.
I agree wholeheartedly with you. And you know, just two more questions. You know, we're tasked on voting in this impeachment today. I wasn't given any access to talk to these witnesses. Do you believe that we who are effectively operating today as a grand jury are deserving of the opportunity to be able to ask questions of those witnesses so that we can get clarity on some of the transcript that we were handed yesterday?
There's two ways to do that from a historical precedent. One is to convene the entire House as a committee on the whole and basically allow individual members to, have witnesses appear before the full House and interrogate witnesses. That might and might not be manageable. But there is another way, which probably is more efficient, and that is to permit members to submit questions in writing that would be asked, members of the House to submit questions in writing to be submitted by committee members under oath in a public forum.
Great, I agree. And, you know, last question, and just once more, do you believe that we should postpone this so that we can have access to actual evidence, be able to question witnesses, and take more time to come up with a deliberative decision?
I'm not sure that we could, technically postpone this proceeding because we're already in the middle of it. But if we voted not to accept the motion today, I do not believe that would prejudice the right of the committee, someone else to file articles of impeachment prior to the end of the session, and for the committee to begin its work after the session has adjourned, which would not prejudice the ability of the full House to be called back under the procedures that are available under the Constitution and the Article 15 of the Constitution and the Government Code to come back for possibly a day or 2 days to adjudicate whether there should be an impeachment or not.
Thank you, Mr. Representative.
Thank you.
Mr. Leach, for what purpose?
Mr. Speaker, will Representative Smithy yield for a couple questions?
The chair recognizes Mr. Smithy.
Yes, I yield.
Thank you, Mr. Smithy. And Representative
Dutton here, I feel like is not gonna get any of his questions answered. I am so afraid for this man. He's like, I want to ask Mr. Murr something, and then it's like, nah.
Representative, thank you for your many years, decades of service here in the Texas House. You're obviously very familiar with the Texas House rules. Are you familiar with Rule 3 regarding the jurisdiction of our House standing committees?
Yes.
And in your time of service here in the Texas House, Representative Smithy, have you ever served as chairman of the House Committee on Judiciary and Civil Jurisprudence?
Yes, I have.
And so, Representative Smithy, you are aware, pursuant to the House rules and as someone who served as chair of the House Committee on Judiciary and Civil Jurisprudence, that committee, pursuant to the House rules, has jurisdiction over several state agencies, including the Office of the Attorney General.
That's right.
Mr. Smithy, is it your experience here in the Texas House that standing committees of the House that have jurisdiction over state agencies regularly invite testimony from the leaders of those state agencies to appear in front of those standing House committees?
I think that's true, and I think sometimes agency heads ask to appear before a committee even when they're not invited.
Is it your experience, Representative Smithy, that when a leader of a state agency is invited to appear in front of a standing House committee, that head of that state agency, that state leader, usually appears and testifies and accepts that invitation to appear in front of the House committee?
Mr. Leach, my experience has been that is not only standard practice, but that's what we would expect. And we would expect agency heads, and particularly in this case, I assume you're talking about the Attorney General. I would expect the Attorney General to make arrangements to be here.
Mr. Smithy, are you aware that I, as chair of the Committee on Judiciary and Civil Jurisprudence, held our first committee of this session on March 1st, 2023, in which I extended a direct invitation to Attorney General Ken Paxton to appear in front of our committee?
I can't say that I am aware of that. I may have heard it at the time. And I will say he should have been there.
Are you aware as to whether or not Attorney General Paxton accepted my invitation to appear in front of our committee?
My assumption from your question is that he did not.
He did not. Representative Smithy, are you aware that at that committee I issued a standing invitation to Attorney General Paxton to participate in any subsequent hearing of the Committee on Judiciary and Civil Jurisprudence?
I wasn't aware of that.
Mr. Smithy, are you aware that our committee, the Committee on Judiciary and Civil Jurisprudence, held a dozen hearings, 12 hearings, during the 88th legislative session in which we took public and invited testimony?
I was at a number of those, even though I wasn't on the committee.
So we did a dozen committee hearings in which our committee, on which Chairman Murr was a member of that standing committee, held a dozen hearings during the 88th legislative session. And to your knowledge, Representative Smithy, did the Attorney General ever participate in or appear in front of our committee?
Not to my recollection, Mr. Leach.
That would be correct. He did not. Thank you, Representative Smithy.
Okay.
Mr. Dutton, for what purpose?
Mr. Speaker, I'd like to ask Chairman Smithy a question.
The gentleman yield for questions.
Thank
Absolutely.
Gentleman
All
yields.
right, he got his question.
It's
Okay, I gotta get off Twitter. It was like slightly in the background and I was paying attention to it.
your understanding that today this House is meeting in similar to a grand jury, is that right?
Yes, as I mentioned, I think it's very comparable to a grand jury in some ways. In other ways, it's possibly not. And the reason for that is because in past precedent, the House has accorded a greater level of due process in impeachment proceedings than you would normally see in a grand jury proceeding.
And in doing so, what is the standard of evidence in this body at this point in time?
Well, Mr. Dutton, my understanding is that by definition, the Texas rules of evidence do not apply to grand jury proceedings. I believe that's Texas Rule of Evidence 101 or 102. Right. They do not formally apply. So there certainly is evidence that can be admissible in a grand jury proceeding that is not necessarily admissible at trial. However, the Texas House has, in precedential authority, has always required that evidence used to impeach a public official, particularly a statewide public official, comply with the rules of evidence in place at that time. In other words, the normal rules for whether evidence would be admissible or inadmissible.
The actual answer to this question would probably be there is no standard of evidence. There is no evidentiary standard to be met. You just vote if you think that yes. Or if you vote no, you vote no. The political game, anyway.
In a court of law in the state of Texas.
Would that mean a standard of probable cause standard, for example?
Well, as far as admissibility of evidence, I'm not sure probable cause is a factor, although it becomes a factor. As far as admissibility, I think the key is that the witness needs to have factual knowledge of the events to which he or she testifies.
Right.
In this case, we have no testimony from any witness who had factual knowledge of any relevant events that were relevant to the inquiry that is at hand. All information was second or even third-hand information. Now, in terms of probable cause, yes, I think that our level of consideration in this proceeding should rise at least to the level of probable cause. But the probable cause must be based on evidence and not innuendo or speculation or accusation. And so as a result of that, my concern is we have no evidence, absolutely no evidence in our record that would justify impeachment. Now, there may be a lot of evidence out there. There may be volumes of evidence that would justify impeachment, but we don't got it. We don't have it. It's not there. And I take this position seriously. We all took an oath, and that is.
I kind of wish Smitty would let Dutton ask questions. I get frustrated with Dade, and I got frustrated with Murr. I get what Smitty's trying to do, but dude, just let him speak.
I've got to perform my duties constitutionally, and as I see it, as I call it, as I perceive it, I can't issue or vote for impeachment based on the record that's presently before the House.
Well, but do you believe that most of the members in here know what probable cause means?
I think some do. Now, many members, as you are aware, are not lawyers, and some lawyers don't practice criminal law. I don't practice criminal law. But I think that we can all understand the concept that there is a very high bar, and there should be a high bar for impeachment. It's not something that we should do casually, not something that we should do just because we don't like somebody or don't approve of the job they've done in office or they didn't show up at a committee hearing.
I mean, having read the articles of impeachment in the Constitution, that could just be chalked up to incompetence. So, like, you could impeach someone on incompetence by not liking how they conduct their duties.
I think we have to set a bar that would...
Oh, and real quick, since I realize it's a time, before we continue, something that's better than an impeachment. Let's go with tea. Tea and coffee from the Dragon's Treasure, a haven for anime and tea lovers, but you can now also get coffee. And remember, use code LAYMAN for 10% off the purchase at the Dragon's Treasure. You can get 10% off your teaware, the tea of the month, the actual Dragon Wings membership, everything. You can get 10% off with code LAYMAN at checkout. Alright, with that, going back to the video.
Incorporate probable cause, not beyond a reasonable doubt. That's for the Senate. But we do have a standard, a bar that must be met.
And as I was thinking about it, I was looking at the board up here where we typically light up the board voting on bills. That standard, would that standard be higher than voting on a bill, for example?
Absolutely, absolutely, because right now we're talking about a vote that will effectively remove a duly elected officer of the state of Texas, elected by a majority of the citizens of this state, from the office that he was elected to less than a year ago, really just about a little over a half year ago. And the public has an interest in that. They should have an interest in that. We are undoing what they did. Now, some people in here may have voted for General Paxton, some people may have voted against, but the majority of Texans voted for him. And this is not just something that affects the Texas House of Representatives, it affects every person in the state of Texas, every man, woman, and child, because this is a statewide elected official. And so we have to be very, very prudent and very, very careful.
Well, let me ask a question about there's a lot of talk been made about the whistleblower lawsuit. Do you know whether that was a lawsuit involving General Paxton personally or in his official capacity as Attorney General?
You know, Mr. Dutton, I've got to confess that up until all of this happened, I paid not as much attention to the Paxton legal proceedings as I probably should have. And so I'm not really aware of the allegations. I'm aware generally of the allegations, but not enough to answer your question.
Well, I guess the question I was getting to is that if he was sued in his official capacity, the state would be on the hook for any damages, whether they were by settlement or by trial. Is that right?
That would be, in the official capacity, that's my understanding, although I'm not an expert on that.
Right. So the last question I have is that when it comes to the members deciding whether to vote for or against this measure to impeach General Paxton, one of the things you raised a moment ago is whether or not his lawyers had ever had a chance to participate in the proceedings, right?
That's correct.
And sometimes in a grand jury, I know you don't practice criminal law, but sometimes in a grand jury, the grand jury may want to hear from the person who is the target of that grand jury. Are you aware of that?
Absolutely, yeah.
Do you know whether, and I know Chairman Leach just indicated he had invited General Paxton to his committee meetings, and I don't know what the nature of that was, but do you know whether he was invited today?
To my knowledge, he was not. Nothing in the record indicates that he was. And I also understand that he was not provided advance notice of the investigation, nor was he invited to produce any potentially exculpatory information or testimony. I really believe that at some point, when you have a statewide elected official, it's only right. I mean, it's only right to go to that official and say, look, we're getting ready to vote on a proposition to remove you from office. Now, if you've got anything that we need to see before we take that vote, you show it to us so we'll know what to do. That opportunity, to my knowledge, was never provided to General Paxton. Someone, I wasn't there, but apparently someone from his office asked to come speak to the committee and was denied that privilege.
Now, are all of the articles of impeachment, are they violations of the law?
I'm not sure I can answer that. Honestly, I've been going through those. We've had less than 48 hours. And I've tried 20 counts is a lot of counts in an indictment or an impeachment. And my problem has been trying to sort what passes as evidence. In other words, the hearsay within hearsay within hearsay, and try to tie it to each count. And I haven't been able to do it. And that's why I was hoping, as part of the presentation, we could have a little organization in terms of what the committee felt supported each of these counts. There must be something there, but I haven't been able to put it together. But once again, we get back, there is zero evidence, zero. And so we're not talking about evidence here.
If there were violations of the law that would determine to be the case against General Paxton, would the committee have a responsibility to refer that to the DA's office?
Absolutely, and that's another concern, is that I think we're all aware that there have been both federal and state investigations into allegations against General Paxton. As far as the whistleblower activities, I know there's been an investigation of that, but I'm not aware of any indictment that's been issued on that. I don't know if the investigation has been suspended or whether it's ongoing. I don't know, and I don't think anybody else really does.
And finally, do you know whether any of these allegations have been referred to a DA's office anywhere?
I'm sure some of them have.
Okay. All right. Thank you, Mr. Speaker.
Mr. Tyndall, for what purpose?
Mr. Speaker, will the gentleman yield for a question?
The gentleman yield for questions.
Yes.
Gentleman yields.
Thank you. So you've been here quite a long time. How many years have you been here?
Well, if I live to the end of this session, it'll be 40.
So you have a lot of experience. So if someone's invited to 1 or 50 committee hearings and they don't show up, do you think that they should still be invited to a general investigating committee in order to defend themselves, regardless of whether they showed up to previous hearings?
And let me say, Mr. Dutton was my classmate. He's the only one left. He and I are the only ones. Let me just say that I think it's inexcusable when a state official doesn't show up for a committee hearing, but I'm not sure it's impeachable, an impeachable offense. I don't know of anyone we've ever impeached in the state of Texas for not showing up at a committee hearing.
So let me ask it a different way.
He wasn't under a subpoena.
Because he didn't show up to those committee hearings, which he wasn't subpoenaed to, he didn't have to come, do you think that automatically makes it so that he doesn't get invited to defend himself?
No. I think that in all fairness, if you're really trying to be fair, you go and say, look, your job is on the line, General, and if you have any concerns about it, if you've got anything that we need to see, you show it to us. That's just fair play.
Thank you.
Gentleman's time's expired. Members, under the previously adopted motion, we are now in the general debate period, equally divided between proponents and opponents of the resolution. The chair recognizes Mr. Murr.
Dutton, get your question out. Get your
For
question in.
questions. Mr. Spiller, for what purpose?
Yes, Mr. Speaker, will the gentleman yield for questions?
Gentleman yield for questions.
Yes.
All right.
Gentleman yields.
Chairman Murr, there's been a lot of discussion about the fact that apparently some of this testimony was not sworn to under oath. Do you recall all those statements that have been made in the questions and answers?
Yes, I recall.
All right. And are you familiar with the whistleblower suit, the petition itself, filed by James Blake Brickman, David Maxwell, J. Mark Penley, and Ryan M. Vassar?
Yes, we've been referring to that since the beginning of our discussions today, and obviously that was a hot topic back in February whenever the parties requested the state to fund a proposed $3.3 million settlement.
And my review of that petition, and I've read the petition, is after page 65. It's about a 120-something page petition, including attachments. But after page 65, it has several declarations. Mr. Brickman, Mr. Maxwell, all the plaintiffs in the case have each signed a statement and verification. Do you recall that?
Yes, I do.
All right. And in fact, each one of those statements and I'm looking at it here now, refers to different paragraphs where certain facts are alleged and says that those matters are in their personal knowledge and that each and every one of those things is true and correct. Do you recall that?
Yes.
All right. As a matter of fact, they go on to say that they state those things under penalty of perjury that they are true and correct. Is that correct?
Yes, there were documents both from that litigation and then, if I recall correctly, documents from the litigation involving the Mitty Foundation, in which depositions were made, including that of Mr. Nate Paul. So there have been multiple documents that have been reviewed that are either transcripts or signed under oath whenever folks talk about that process.
And I think you mentioned that there was deposition testimony of Nate Paul that was contained and referred to in the materials that we've received.
Yes, that is correct.
All right. And so to characterize this as saying that none of the information, none of the statements were sworn to or verified, would you say that that is a misstatement?
Yes, I would say that's a misstatement, and I would also add that there is nothing in the House rules, in statute, or in the Constitution pursuant to these proceedings that we have to go get sworn testimony in the House as far as the investigation into any allegations of wrongdoing. That is not what is required. That is not necessarily what law enforcement does whenever we equate this to a process, even though it is not criminal in nature. But we've talked about this concept that the House serves similarly like a grand jury. So the House itself receives information, and even Mr. Smithy made a point earlier that that level of information is going to be different than what would be admissible at trial. And here, trial does not occur in the House. Trial occurs in the Senate. And in the Senate, presumably rules of evidence would be required. Witnesses would be subpoenaed or voluntarily show up, and they would have to be under oath. So we have gathered a lot of information. Now, some of the witnesses that were sought out and interviewed as part of our process were done so pursuant to subpoenas that the committee issued. No witness sought to quash those subpoenas. There's methods out there to say, hey, I don't want to do this. So those subpoenas came in and they willingly sat down once they received a subpoena and testified. And then the final thing that I will point out, as far as the committee's work and the efforts that we undertake, is that we have to be conscientious that if the committee requests someone to come testify and they raise an issue that say that if I provide testimony or produce a document and I think that violates, essentially a Fifth Amendment right and will get me in hot water, then we can still compel them to testify or produce, and they will receive immunity. And that essentially is immunity from prosecution of state law. And so we have to be conscientious and careful about what the committee does, or we wield an immunity power.
So to recap some of this about the sworn testimony, these individuals, and I think that you've already attested to it, as well as some others previously today, have talked about these four people were some of the top people at the Office of the Attorney General, correct?
Yes, that's right. I think folks are forgetting the fact that division chiefs, these are people who help run one of the most important agencies in the state of Texas. They identified wrongdoing, they reported it to law enforcement, and they were fired. They had a lawsuit against their boss, and they did provide sworn statements in that lawsuit. In addition to that, either through a subpoena or at our request, they sat down and spoke with their attorneys present, with our investigators, and our investigators and attorneys downloaded that information to us. The full expectation here is each one of these people that sat down and helped us gather information is expected to testify at trial under oath. Yes.
And so much of the relevant portions of what we've covered today as far as the allegations, all of those have been sworn to by each of these individuals that are listed as plaintiffs in this suit. Is that correct?
That is correct. Yes, sir.
And let me ask you this, with regard to your understanding from visiting with the investigators that this committee retained, is it your understanding that all of the testimony that it was gathered and received, because many times in an investigation you'll have, maybe somebody recalls something slightly different, or there may be slight differences of recollection of facts, but do you know of any pertinent facts, relevant facts, facts that apply in this instance from any of the witnesses that did not fall completely in line together with the testimony of each witness that the group sought testimony from?
Emphatically no. Importantly, we ask our investigating attorneys, did you find variations whenever you went out and sought these facts? They said no. They all interlock. They all corroborate each other. They're all accurate, whether it is statements made in litigation previously or the fact that they were interviewed separately and it come to find out that they all had a common recollection of facts, and that indicates that they're accurate statements. We would rely upon that when we present it to this body to say, we're asking you to consider sending it to trial in the Senate, and we expect those people to show up and offer their testimony under oath there.
And also, Chairman, with regard to each of these individuals signing under penalty of perjury, you understand that perjury is a criminal offense and is a felony criminal offense punishable by confinement in the penitentiary.
That is correct.
All right. Thank you.
Yes.
Mr. Dutton, for what purpose?
I'd like to ask questions.
Will the
of
gentleman
Mr.
yield for
Burr.
questions?
Yes.
The gentleman yield.
Dutton finally gets his questions in. God damn. The man's been so patient.
Thank you. Mr. Murr, can you tell me which of the articles of impeachment are actually violations of the law?
So I'm going to answer your question. I'm going to first point to the memorandum that we distributed, our committee distributed to members yesterday, both electronically and in paper format. As you may be aware, while our Texas Constitution finds a lot of similarity with the United States Constitution, the Texas Constitution is absent when we talk about whether or not it includes a list of impeachable offenses. So I think I'm going straight to your question to say there is no requirement under the Texas Constitution that an impeachable offense be a violation of criminal law. And I want to speak to that just a little bit. Importantly, this body, in a report that was provided previously in regards to the impeachment that's been discussed in 1975 of a district judge, said that undermining the integrity of office, disregard of constitutional duties and oath of office, the arrogation of power, the abuse of governmental process, and the adverse impact on the system of government are, in effect, impeachable offenses. And they reviewed the American law on impeachments. And they finally concluded that while it's in relation to criminal law, impeachment is designed to cope with both the inadequacy of criminal standards, that means we may or may not have a criminal law in place for it, and the inability of our court system to deal with the conduct of great public figures.
I understand that, what you just said, but I don't believe you understand my question. My question was simply, which of the articles of impeachment are violations of the law? I'm not...
I love Dutton. I love this man. He's fantastic. Ask the question. Guy basically prattles on for everything but the answer. Like, I don't think you understood my question. I just asked this question, so I'll ask it again. Oh, man.
I'm not saying that they have to be or they don't have to be. I'm just asking, are there? And if there are any that are violations of the law, would you please point me to them?
Does this man have a Twitter account? I need this man's Twitter account. What's his house? Dutton. Harold Dutton. Oh man, this guy getting hate. I love this man. He's great. Alright, I'm gonna get back to it.
I am retrieving a copy of my resolution, so
Okay.
please give me a moment. Article 1, protection of a charitable organization. That is a violation of duties of his office. Article 2, abuse of opinion process. Presumably that would be misuse of the government code and the power and process for issuing written opinions. Article 3, abuse of open records process that's set out in Chapter 552 of the government code. We've cited that in Article 3. Article 4, misuse of official information. We again cite Chapter 552 of the government code. Article 5, disregard of an official duty. We talked about the violation of laws governing the appointment of prosecuting attorneys pro tem. There is a specific process in place in which an attorney pro tem can be involved. And Mr. Spiller did a really good job of explaining that to the body, that said that really only occurs whenever the local prosecutor recuses themselves from a case or makes a request for additional assistance because their office doesn't have the necessary staff or skill set to prosecute a case, and so the AG's office does. As you heard, the AG's office has over 800 experienced criminal prosecutors that help in those matters. So that process didn't unfold according to what we've set out in law. Article 6, relating to the termination of whistleblowers, clearly against the law. Article 7, regarding whistleblower investigation and report. We talked about the fact that whistleblower complaints were made and public resources were misused. Article 8, regarding the settlement agreement. The allegations there are that it was staying the termination in effect forever if no settlement funds were paid. Article 9 relates, and 10 relate to constitutional bribery, and that is found in the Constitution. Article 11 relates to obstruction of justice. As said by its title, it references violations of the Securities Act, which is Title 12 of the Government Code. Article 12 refers to obstruction of justice regarding protracted delay in criminal cases, and that's an abuse of judicial process. When we talk about Articles 13 and 14 and 15, that has to do with false statements. Typically, false statements are made because those statements are required by law. Article 16, conspiracy and attempted conspiracy. We do have penal code provisions relating to both of those charges. Misappropriation of public resources. If one causes employees of your office to perform services for your benefit, that can be a violation of law. Dereliction of duty alleges violations of the Texas Constitution, oaths of office, statutes, and public policy for public officials. So based on the evidence and the information we provided, we think the conduct does that. Article 9, well, permit me the last two. I've had to go through all of them, so let me get the last two, sir. Right. Article 19 speaks of the unfitness for
I hate Murph. He talks and talks and talks.
Office. You will read treatises that deal with impeachment because it's not an occurrence that's common. So we all look to what the American model is, and that's been studied both in 1917, that's been studied in 1975, and we've seen that how other states treat that. Right. So that and abuse of the public trust at the end don't necessarily violate what we might say is law or the penal code, but they do violate what was set forth in the Texas Constitution, which doesn't require a threshold for an impeachment.
Right. And finally, have you referred those violations of the law to any law enforcement?
The expectation is the committee in due course always does that. So,
but you haven't done that at this point?
Have not done that yet.
Okay.
Still have subpoenas out, sir.
All right. Thank you.
The gentleman's time has expired. The chair recognizes Mr. Dutton to speak on the resolution. Mr. Toth, for what purpose?
Can we get an extension of time?
There are no extensions of time.
Thank you, Mr. Speaker and members. Mr. Smithy and I have been here.
Mr. Schofield, for what purpose?
A parliamentary inquiry.
Please state your inquiry.
I have requested to speak against the motion. Will I be recognized to do so?
Yes.
Thank you.
You're on the list, Mr. Schofield.
Thank you, Mr. Speaker. Mr. Smithy and I have been here. This is our 20th term. And like most people here, everybody here, we have not, I don't know, Mr. Craddock or Chair Thompson may have been through this before, but this is the first time we've ever done this. And we're asked to do something that just doesn't happen very often, but we're asked to do it almost in the dead of night. One of the things I do when I practice law is that I realize that what the prosecutor does first in any kind of proceeding is they always make the jury kind of mad at my client so that whenever they're rendering a verdict, it's going to be more about, sometimes about being mad at the person than what the person actually did or didn't do, for that matter. Today, you're going to be asked to vote on the board, and you got three choices. You got present, not voting. You got yea and aye and no. That's generally what we use for voting on bills, where we decide that, well, if you like a bill, you vote aye. If you don't like a bill, you vote nay, and sometimes you vote present, not voting. And admittedly, sometimes you vote based on who the author is or isn't. And I recognize that, and we all have been guilty of doing that. But today you're asked to vote not just the way you would vote on a bill or against a bill. You're asked to do a little bit, there's an increased standard. And I admit to you that Mr. Murr told me that at some point in his closing, he is going to help you understand what that hurdle is that you have to get over before you make a vote, either aye or nay. Because in a proceeding like this, one of the things you want to do is you want to make sure that you're not voting based on whether you're mad at the person. Now, I don't want this to be partisan either. The election was held back in November, and so it was decided. I suspect that most of the Democrats in here didn't vote for General Paxton, like I didn't. I suspect that most of the Republicans in here did vote But that's not what this vote is about today. It's not having the election all over again. This is whether or not you believe that General Paxton ought to be transferred over to the Senate. His policies and practices ought to be transferred to the Senate to make a determination as to whether or not he ought to be impeached. That ought to be a pretty high standard for us. That ought to be a pretty high standard. And it ought to be a standard that's higher than politics, higher than our politics. Because if we just base it on politics, all the Democrats would vote aye and all the Republicans would vote no. But I suspect that that's not the way it's going to happen here. For me, I am speaking on this bill because I intend to vote a white light. And I intend to vote a white light not because I don't believe General Paxton is guilty, not because I don't believe he's innocent, but I do believe that the process, as you've heard from my good friend Chairman Smithy on down, that the process ought to be such that we are convinced that going forward is the best thing for this House to do, is the best thing for this House to do. And we ought to do it absent any emotions or emotional feelings about General Paxton. That's not what this is about. If it was about that, I would go to my seat and it was just based on emotions, I'd vote to kick General Paxton out today. He wouldn't have to go to the Senate. He can just do it from the House and let him be gone. But I don't think that's what we ought to do, members. I think we ought to pay attention to this very closely. Because what we're doing is not only to General Paxton, but it's doing it to the citizens in the state of Texas. Because they voted for General Paxton. I didn't, like I told you, but the citizens of Texas voted for General Paxton. And I think that we ought to honor that, at least to the extent that we are convinced that General Paxton abused his office to the point that we ought to be able to go to the Senate side and vote for impeachment of General Paxton. Now, I will tell you that this is not a difficult decision for me because I never get to the point of whether General Paxton is innocent or guilty. I don't do that. I do this because the process by which we're getting this done seems to be abbreviated to the point that that just encroaches on due process. And I believe everybody ought to respect the due process rights of everybody here, everybody in their district, and every Texan ought to be afforded their due process rights. There was a time in my history and the history of black people in this country and in this state that we didn't get due process. Sometimes they found us guilty and then they had the trial. And I don't think that's what we ought to do today. I don't think that's what we ought to do. I don't think we ought to have decide to find General Paxton violated anything without the due process rights being protected. And so, Mr. Speaker and members, I would ask you to at least pay attention to your vote. This is not, like I said, voting on a bill.
Mr. Kane, for what purpose?
Does the gentleman yield for a question?
Will the gentleman yield for questions?
Well, yes, I'll yield for my good friend,
The gentleman yields.
from Maverick's dad.
You're discussing the determination of guilt or innocence. Do you believe that's something that this body's supposed to determine as the House?
Not really, not really. We're not supposed to be determining guilt or innocence. We're supposed to be determining whether there is probable cause to believe that General Paxton is the person who committed whatever it is they're saying he committed. That's what we're supposed to be doing.
Okay. You're discussing, wanting to hear more evidence and things. Do you believe that's also something the House does, or is that the responsibility of the Senate?
Well, I think there ought to be a standard here, Chairman Kane. There ought to be a standard here, and then there's an even higher standard when it gets to the Senate. Because I believe that in order for us, you've heard the expression that it's in Texas you can indict a ham sandwich. And that's because You know, you're right. The limited evidence that a person has to have, that the prosecutor has to have, in order to perfect or get an indictment, which is why sometimes we end up challenging the indictment. And sometimes we win at that because the indictment is so full of holes, and that's what I think this is.
Thank you, sir.
I think there are holes here.
Mr. Guerin, for what purpose?
Mr. Speaker, would the gentleman yield for one
Yes.
question?
The gentleman
Yes.
yields.
Thank you. Mr. Dutton, one of the complaints had been that the paperwork was put on the desk only 2 days ago. And I understand that's a short period of time, but in less than an hour after the papers were put on the desk, are you aware that the Attorney General himself called members of this House while they were sitting at their desk and threatened them?
I was not advised of that until I heard you say that.
I mean, God bless the poor senators. I don't know how long it'll be if this passes that they're going to have to put up with that same intimidation tactics from a man that does not deserve to be in office.
Well, I understand what you're saying, Charlie, and I would be on your side.
Mr. Canales, for what purpose?
If my dear friend Harold would yield for some questions.
Yes, I do.
The gentleman
Thank
yields.
So, Mr. Dutton, it is your position that the process is flawed because the Attorney General wasn't afforded due process. And we've heard earlier this is similar to a grand jury proceeding. So in that context, what is it about this process that you believe is so flawed?
Well, I don't believe that we've had the full, I mean, if you've convinced that the evidence, if I asked you, what is the evidence that exists in your mind right now that General Paxton, more likely than not,
That's not my
committed a
question,
crime?
Mr. Dutton. My question is, what is the problem? You said the process was flawed, and I'm asking you, of an attorney to attorney, because I've been practicing for almost 20 years myself, what is it that you think's flawed?
I'm not convinced. I'm not convinced that we ought to go forward. That's what's flawed.
Okay, so but then it's not the process, you're just not convinced.
I'm not convinced. I don't have enough evidence. I don't have enough evidence that tells me that he did anything.
Okay, that mean you're not convinced, but that's not answering the question that the process is flawed. You just don't believe they presented enough evidence then.
Sir, that's an argument that I can make to you that if the process wasn't flawed, I would have enough evidence.
Okay, so in a grand jury proceeding, you were talking earlier with Mr. Smithy about grand juries calling witnesses, and I can tell you I've represented thousands of clients, and I can't even count on one hand how many of my clients have ever been asked to go testify before a grand jury. That is not common practice. It's possible, but it's not common practice, is it?
Well,
the gentleman's time has expired.
Thank you.
The chair recognizes Mr. Schofield to speak in
I
opposition.
will admit that is a little bit of an argument against Dutton. As much as I have begun to like him, that's probably the fairest argument against his whole case there. And I would say he kind of got saved by the bell there.
Opposition to the resolution.
Mr. Speaker, members, it is with great sense of concern for this House that I rise in opposition to this rushed motion to impeach a statewide officer elected by the people of Texas. Like most members of the House, and like virtually all of the 30 million people in Texas, I began this week with no idea that the House was considering impeaching the Attorney General. Now, here at the end of the week, we are preparing to remove him from office before the day is out. There is no need to rush to judgment. Impeachment in Texas isn't just rare, it's virtually unique. Only twice in the history of our state have we impeached an elected official, the most recent being half a century ago. Despite the colorful history of public officials in Texas, only twice has this House determined that their conduct rose to the level where they should be removed from office. And only twice more did the House conduct proceedings that ended without impeaching the official. The process we are conducting today is unprecedented in the history of Texas, Every other impeachment ever conducted by this House included several public hearings in committee with dozens of witnesses. By the time we take the exceedingly rare step of moving to impeach a public official, the entire state should be talking about it and should be outraged. Process isn't just an esoteric concept that lawyers insist on. It's how we guarantee all of us have rights. In an impeachment, the conclusion isn't the only thing that matters. If we are going to remove a statewide elected official elected by the people, those people have a right to be included in the process every step of the way so they can draw the conclusion along with us. We all know that in any argument, people accept the conclusion, the end result, better when you lay out the facts of the case and let them reach the conclusion rather than just telling them this is how it is. Historically, as you have heard, our impeachment proceedings have been even-handed, including the right of the respondent to question witnesses. The two successful impeachments of Governor James Ferguson in 1917 and Judge O.P. Carrillo in 1975 were conducted with open public hearings and cross-examination of witnesses by both sides. And when Judge Carrillo was not given subpoena power, most of the witnesses he requested were, in fact, subpoenaed. The Carrillo impeachment hearings were held over 2 months in May through July of 1975, including 21 meetings where the committee heard from 32 witnesses. In 1929, the House considered a resolution to impeach Land Commissioner James Robeson. Our process this week is so rushed that I didn't have time to fully research the history of those proceedings, but the hearings in the Robeson matter were apparently held before the entire House, sitting as a committee of the whole, with counsel for both sides addressing the House and over 36 witnesses testifying where you could see them directly if you were a member of the House. That proceeding ended with the House deciding not to impeach. Similarly, the impeachment proceedings of Governor Ferguson were conducted by the entire House as a committee of the whole. The governor was allowed to attend the hearings and be represented by counsel who was allowed to participate. The House heard from 39 witnesses, including the governor. In the Carrillo matter, the members of the House knew about the investigation for months before it came to the floor. The investigation began in May. The committee report was signed on July 17th, and the House considered the matter on August 4th, not 2 days after hearing that impeachment was a possibility. In the Ferguson case, the first resolution of investigation was introduced on February 14th. Hearings began on March 7th. The House finally voted on articles of impeachment on August 24th. The investigation on Land Commissioner Robeson began in public in January. The House took up the impeachment on June 10th. Contrast those proceedings with those in which we are currently engaged. This current process was done in secret, so much so that most members of the House didn't even know the impeachment of the Attorney General was being considered until at most a couple of days before the articles of impeachment were filed this week. There was no public testimony, no chance for the public or even members of the House to learn about the allegation and look the witnesses in the eye. There's a reason why we have the concept of hearsay. Testimony given outside of court where you can't see what the witness is saying, you can't judge his demeanor, is considered less credible than when you can look the witness right in the eye. Not just the entire House, but the public should be aware of the investigation and of the possibility that it might result in impeachment. There is no cause to sneak up on the public with the removal of a statewide elected official. It reflects poorly on the House when we suddenly spring an impeachment on the public that they knew nothing about, much less had the ability to draw their own conclusions on seeing the evidence play out in public hearings. Instead, all we have is the transcript of a meeting, I can't even call it a hearing since no witnesses were heard, in which the committee staff briefed the committee on what the staff had discovered in their investigation. In no court anywhere would that be considered evidence. Not a single witness testified to the committee, and no report was issued. We are simply being handed a transcript of the staff's conversation with the committee and being asked to vote to remove a statewide office holder who was elected by the people. Now, I want to make it very clear, as Mr. Smithy did earlier, that I am not blaming the committee for this process. The committee is made up of 5 members, 5 of our most able and honest members. I've dealt with most of them on legislative matters in the past and can state without reservation that I trust the word of the members that I've dealt with. My concern is with us as a House. I am gravely concerned that we let the matter of former Representative Brian Slayton serve as a precedent and leave us with the impression that the committee goes off and writes a report and we all just read a copy and ratify it, removing someone from office to which the public has entrusted them. In the Slayton case, there was very good reason for the hearings being conducted in secret. There was a young woman involved whose very personal business was at the center of that investigation. Moreover, she was an intern in the House entrusted to our care. That investigation was handled very delicately and very sensitively, as it should have been. This case is in no way analogous to the Slayton matter. There is nothing I'm aware of in this investigation that should not have been made public all along the way, so members of this House and the people of Texas could see the evidence as it was adduced and draw their conclusions along with the committee. By the time this matter reached the House floor, all the details should have been very well known to every Texan who cared to know. There is no need to rush headlong into impeachment. There is nothing about the end of session on Monday that in any way impacts the House's ability to continue with impeachment proceedings. That was definitively stated by the Supreme Court in Ferguson versus Maddox.
The gentleman's time has expired. The chair recognizes Mr. Hayes to speak in opposition to the resolution.
Man, he was on fire. I liked what he was saying. I didn't expect Slatton to get brought up again. I kind of thought he'd just be a gone memory. That man's a pervasive legacy in the House for his removal. Good shit. But before we continue on with that, you know, it's also fire. God damn it. Dragon's Treasure, a haven for anime and tea lovers. It is a place you can get fantastic tasting tea. I promise. I've tried it before. I've in fact been drinking the Sebastian Morning Earl Grey, which you can find right here, with vanilla cream. It's a black Earl Grey flavored. Black tea, orange peels, blue cornflower, natural vanilla flavors, and natural bergamot flavors, and natural cream flavor. So remember, use code Layman at checkout for 10% off of all merchandise, Dragon Wings membership, the tea wares. You can get a shirt, you can get coffee now. He's now a coffee seller. How about that? Whenever I get it, I will make a review of it whenever I stream. So I'll make sure that you guys get that as well. But remember, at checkout, use code Layman for 10% off your purchase and enjoy some fantastic tea with some fantastic savings. What's up? The Solver's Opportunity. Follow to. Alright, I'll check that out later.
Mr. Speaker,
I hate that sound.
Members, guests, I have the honor of representing Denton County. This morning, I attended a fallen heroes memorial service here at the Capitol in this very room. And at the conclusion of the services, as the bagpiper played Amazing Grace, I teared up. It framed the somber duty we are facing this afternoon. I ask for prayers, not only for me, but my fellow members of the House, that we shall be blessed with wisdom and honor on this very sad day. I begin by recognizing the difficult and weighty undertaking of the House General Investigating Committee. However, I rise to speak against the preferring of articles of impeachment against General Paxton. My concerns include the speed at which this process is proceeding and the lack of direct evidence and firsthand testimony. As you've heard, the members of this House knew of the investigation by the committee was on Wednesday. Then Thursday evening, about 8:30, for the first time, we were presented the articles of impeachment. And then today's proceeding commenced just 48 hours later. There is no question that the allegations are serious, alarming, and stunning. But even those that are the guiltiest are entitled to a fair and reasonable process. It is unpersuasive to me that we can shift that to the Senate when they undertake the trial. One of the founding principles of our system of government are checks and balances. At this stage of the process, the House is the initial check. I fail to understand the urgency of proceeding at breakneck speed. I implore my fellow members to slow the roll. While rarely wise for a defendant to appear before a grand jury, and as you heard from Mr. Canales, especially when serious criminal charges are pending, General Paxton's press released yesterday that he wanted the opportunity to appear before us. Quite frankly, that opportunity should have been afforded at the committee level. While totally ill-advised, that opportunity should be afforded to him, and if not to him directly, to his attorneys. I have heard from many of my friends and constituents during the last 48 hours, as I'm sure many of you had. The speed and transparency of this process has been described in their emails using such words, and these are their words, as being a political setup, steamrolled, sham, political whack job, weaponized political prosecution, railroaded. These are not my words, but the words of concerned citizens. Our citizens are concerned. They want fairness. Members, this process is important, and if impeached, General Paxton will be suspended as Attorney General, and a replacement will be appointed by the governor. Before we remove someone from their office and duties, let us be the deliberative assembly that we are. Slow the roll. Let us review the witness statements, hear witnesses, and review documents. I thank you for your consideration. And members, I ask that you consider white-lighting your vote to register protest to the process. We can come back another day. Thank you, Mr. Speaker.
The chair recognizes Mr. Leach to speak in favor of the resolution.
Thank you, Mr. Speaker and members. Members, I did not plan to speak today. I didn't want to speak today, but felt compelled to stand in front of you as we approach this historic vote with a few words. This morning I woke up and in preparation for the vote was, like many of you, reviewing and reading and considering all of the messages from our constituents, from people all across this state as to how they would wish us to vote today. Many messages of prayer for us, for me, and for you. And on behalf of the entire Texas House, for those of you here today and for those of you tuning in, we thank you. We thank you for voicing your opinions to us. They value to us. This is your house, and your voice here matters. This morning I received a message from one dear friend and a former colleague here in the Texas House, David Simpson. David Simpson is no stranger to this House. He is a true friend to the state of Texas, and he is an unquestioned warrior for the conservative cause. David's actually here in the chamber today, just off the chamber. I hope you get an opportunity to, if you haven't seen him in a while, to go say hi and to hug his neck, and if you've never met him, to go meet him. But you've each received at your desk a copy of the statement from Representative Simpson. I encourage you to read it, and I want all Texans to hear his words as well, and so all I'm going to do simply today is to read his words into the journal for the record. This is Representative Simpson. Honor and humility, where are they? Human life is sacred, but it's not fair. As image bearers of God and the crown of God's creation, humans from every tribe and tongue have intrinsic worth, dignity, and responsibility. That makes humanity unique. It also compels us to strive to see that all humans are treated equally before the law. The fact remains that we are not equal in power, intellect, experience, and opportunity, nor do we use what we have equally. Some achieve great notoriety, some live in oblivion, some appear to do great good, and some great evil. Most of us are a mixture. We all, at times, are in positions of power over those who are weaker than us, those not as quick, those not as experienced. That's when our principles are tested as parents, teachers, employers, police, pastors, and judges. Honor and humility mark those who refrain from using power over another unnecessarily. They impel us to forgive and forget injury to ourselves and seek to move forward. Oftentimes, though, honor and humility forsake us. Pride, self-righteousness, and revenge can overwhelm us. Before we know it, we can abuse our powers over children, students, employees, parishioners, and citizens. Sometimes, though, a proper and legitimate use of power is neglected, and those under our care and jurisdiction suffer from not having their irresponsible behavior exposed and corrected. Recent actions in the Texas House remind us of the importance of these principles. When Representative Andrew Murr, chairman of the House General Investigating Committee, laid out the resolution to expel Brian Slayton from the House, it was accompanied with humility, sorrow, and grief. I had supported Slayton's election, but could not condone his behavior and the abuse of power in office. I'm both saddened and heartened, too, that Chairman Murr and the Committee on General Investigating is calling for the impeachment of Attorney General Ken Paxton. He appears to show little or no contrition for scandalous behavior while in office. He is unwilling to resign, but he is asking the legislature, ultimately us as taxpayers, to fund a $3.3 million settlement for a wrongful termination lawsuit brought against him by whistleblowers for abuse of power and persistent misdeeds after being elected. Republican leaders and loyalists are attacking Speaker Phelan with ad hominem instead of dealing with the fact that our Attorney General has asked the legislature to appropriate funds to ameliorate his misconduct while being the highest law enforcement officer of our state. How can legislators do that with honor? Honor demands that those in authority use their power to try him and remove him from office, not out of vindictiveness, not to seek political advantage, but out of compunction, not from condescension, but in humility, believing that with the grace of God we would resign if we fell into the same circumstances and we betrayed those who we are sworn to serve. May God help us to pass this test that is before us, to proceed not only with honor and humility, to despise partisanship and politics, and uphold integrity both as office holders and citizens. May the members of the Texas House and Senate imitate Representative Crockett, who while in office in Tennessee said, "I have always supported measures and principles and not men. I have acted fearlessly and independent, and I will never regret my course. I would rather be politically buried than to be hypocritically immortalized." David Simpson, May 27, 2023, Avenger, Texas.
The chair recognizes Mr. Canales to speak in favor of the resolution.
Thank you, Mr. Speaker, members. I also had no intention of speaking today. But the reality is I've heard too many disingenuous statements. I cannot sit in the back as an attorney, practicing attorney almost 20 years, and watch members weave different concepts together to misguide you and the public. So let's start with Representative Smithy talking about hearsay and hearsay within hearsay. Well, the rules of evidence provide many exceptions where hearsay is admissible. But hearsay is never excluded from an investigation. And that's what this is. This was an investigation. So if they heard hearsay or hearsay within hearsay, that rule doesn't apply to investigations. You've also heard that we're somewhat like a grand jury, and probable cause is what we're supposed to be looking for. That's one of the lowest thresholds. You heard Mr. Dutton say, a grand jury can indict a ham sandwich. Well, that's, unfortunately, how our legal system works. The threshold to end up sending someone to trial is relatively low. And you also heard that the system or the methodology by which we got here was not open. Well, I don't know about you, but I knew it was happening. I actually went and sat in the hearing. So the members that got up here and complained that they didn't know, perhaps weren't listening, perhaps were meeting with some lobbyist somewhere. But I sat and watched the hearing. I sat and listened to it. And I began to count the felonies. I ran out of fingers and toes. What I'll tell you is, you keep hearing why now and why this time. Well, there's never a wrong time to do the right thing. And today, I stand before you to tell you that the investigation was carried out much like any other investigation that I've ever seen as a defense attorney of almost 20 years. Rarely in my entire career, I've never had one single client invited to speak to the grand jury. Never. It doesn't happen. If it does, it's extremely rare. Never do you ever see the witnesses all brought before the grand jury. Generally, the DA lays it out, just like Mr. Murr did. That's how it works. In fact, everything that I've seen in this process is almost exactly like I've seen an investigation, like I've seen a grand jury, and like I've seen things conducted in the legal world that I have lived in for almost 20 years. You've heard that there were no witnesses. There were dozens upon dozens of witnesses that were spoken to. You heard they weren't under oath. Mr. Murr told you some of them are under oath. Some of them weren't under oath. But there are witnesses upon witnesses. You must leave this chamber today knowing one thing that you will have to do for the rest of your life. So look in the mirror and ask yourself, after hearing all these things, did you do the right thing? Did you do the right thing? Or did you stand here and put politics above justice and morality? You know, you heard Mr. Smithy talk about my father, that he had introduced impeachment resolutions. Well, by God, he was a Democrat, and he impeached, and they impeached a Democratic district judge. This is not about politics. This is about justice. And maybe justice delayed is justice denied. Well, the citizens of Texas have been denied justice for way too long. It is this body's obligation, and it is within our power. You also heard that this has all been a secret. Hell, if they'd have read the rules, you'd have noticed that we put it in the rules this session, that we have the power to investigate and bring articles of impeachment. That was on January 10th. Right there in the rule book. I can read them to you, but I can't make you understand them. The reality is this, members. We have a decision to make here today. Do we listen to our colleagues, a bipartisan committee that sat and listened to hours of testimony, that held that investigation since March, that come before you, members of the highest integrity, Representative Murr, Representative Johnson, Representative Longoria, Representative Spiller? I've never been lied to one of them once, about one of them, never. In fact, I hold them to the highest regard. I tell you that I have faith in them. I have faith in you. Fear not politics. Fear corruption. Vote yes.
The House will now hear closing statements on the resolution. The chair recognizes Mr. Clardy.
Thank you, Mr. Speaker, members. There we go. Can you hear me all right? There we go. Thank you, Mr. Speaker, members. It's my intention, I want you to know, to vote against the resolution for the impeachment of General Paxton. I want to explain why. I think it's important for the body to know how I come to this conclusion. Like many of you, I've not come to it lightly, and I have come to it in a bit of a hurry because we've only had 72 hours to really think about this. If you'd asked me last Saturday, what do you think you'll be doing next Saturday? I promise you, one thing that would not have been on that list is engaging in an impeachment proceeding against Attorney General Paxton. But yet here we are. You know, usually I stand before you as a fellow member of the Texas House of Representatives. Today I stand before you as a grand juror, just like you were grand jurors. And we're being asked to make a decision that would result in the removal of a recently re-elected constitutional officer. I want to say this as a member who probably has tried at least as many or more jury trials as any member in this chamber, or anybody in this gallery, I would probably say. And because of that, I'm an absolute staunch supporter, an absolute believer in the Fifth and the Seventh Amendments, and our jury system and the role of jurors. And this is the process you and I are about to engage in. It is our responsibility to sift through the evidence, to judge the character of the witnesses. That's why our jury systems works. That's why it's so important that we do this. So when I look at what we're about to do, I'm reminded with the presentation. Let me say this about our colleagues who served on the House Investigating Committee. I think they have done yeoman's work. They've worked hard. They're diligent, honorable members. And one of those is my good friend, David Spiller. And when he opened today, he made a comment, there is sufficient evidence for further legal proceedings. Members, I will submit to you, there is no evidence for future legal proceedings based upon the record here today. I'm not saying we couldn't have gotten there, but we're here where we are now with what we have. It is a fact that this is predicated, as Mr. Smithy said, hearsay upon hearsay upon hearsay. Our members and colleagues said, here's what we were told in a meeting. And yes, I did watch the video. Yes, I have read the transcript. But what I saw were the backs of people's heads telling our members, this is what we heard from somebody else that we talked to, and to my knowledge, none of whom were under oath, nor were they subject to cross-examination, a very important part of the legal process, the crucible by which we get to the truth in our courts. That's important to us, members. We have got to be the ones who gauge the credibility and the strength of the witness, and I am telling you here today, there is no witness, there is no evidence before us. There is nothing competent in a court of law that would be admissible in that court. But this isn't just about now. This isn't just about what we do here today. This isn't even about General Paxton. The day is going to come, and quite soon, I think, that many of us may move from this chamber over to the Texas State Cemetery. In a decade or 2 or 3 or 4 decades, something will come up again in the future of Texas. They will say, well, what should we do? How do we handle this? And we will do what we've done here, albeit in a very rushed fashion, go back in history and look, how do we deal with impeachment? We haven't done this in 50 years. That's been the pattern, it seems. And we will get into that, and they will dig up this record. To undertake this effort, and I want you to remember this, members, because we've all been through this last week. This came up, my first knowledge, 72 hours ago, during the busiest week of the session. We're hearing this on 3 days' notice on the Saturday of a 3-day weekend, Memorial Weekend, where we should be recognizing the members of who've given their lives in service of our country, but instead we're here. And then we sine die in 2 days. We're on day 138 of a 140-day session. To do that now just seems wrong. And I will tell you, if they look back on this record and we act on the record we have before us, I may be rolling over in that grave because I will be embarrassed and I will be disappointed by the process and the rush to judgment that we seem to be hurtling towards and engaging in. I hope future houses will disregard the proceedings we are setting here today, that they will look back and say, you know, we don't know what we're going to do, but we're not going to do that. We're not going to do that. We're not going to rush this thing through. We're going to provide due process. We're going to have operation of law. We're going to hear real evidence. We're better than this. We owe Texas more than this. And we owe those that will come after us and sit in these very chairs, that will come after us in the House that we all love, to set a better standard, to set a better record, to make a record we're all proud of when we act. I urge you to join me in voting against the resolution for impeachment of Attorney General Paxton. Thank you.
The chair recognizes Mr. Toth in opposition.
Mr. Speaker, members, several years ago, Montgomery County had 3 elected officials who were accused of violating the Texas Open Meetings Act. A special prosecutor was appointed, a grand jury was seated. I received a call shortly thereafter from the special prosecutor asking me to appear as a witness before the grand jury. I asked him if I was to testify before the grand jury, and he said, you were. I said, isn't this unprecedented to have people involved in the case be direct testimony before the grand jury and allow them to ask us questions? And he said, Steve, you got to understand something. We may usurp the will of the voters by removing 3 members of this court. We have to be absolutely sure that they have access to firsthand evidence. Here we are in the Texas House. We're being asked to potentially usurp the will of Texas voters based on no direct evidence by witnesses who were properly deposed that were never sworn in. This has been nothing but hearsay. We heard that a document, a 340-page document, was removed from the Texas Office of Attorney General's site. Yet if you Google search it right now, you can find that document on their site. Fact, we heard that an OAG opinion had been issued about foreclosures of property. No such opinion exists. That was nothing more than a letter of guidance from the OAG's office. There's a huge difference, and we all know that. I am not commenting on Mr. Paxton's guilt or innocence, rather the lack of credible process that has gone on today. Members, we're establishing a precedent for actions of the future. All the testimony by this committee and members will be placed in the House Journal for future generations. And by moving forward without proper guardrails on the initial removal of a statewide official sets Texas on a dangerous path. I ask you to tap the brakes. Let's make sure we do this the right way and not the wrong way. Please vote no.
The House will now hear closing statements from the committee. The chair recognizes Mr. Murr.
All right, we're at going towards the end of this. Let's go. I really hate that sound.
Members, Mr. Paxton brought this matter to us. Let me repeat that. Mr. Paxton brought this matter to us. In February, after signing a settlement agreement that stopped the litigation process in a whistleblower lawsuit brought against him by some of the highest-ranked individuals in the Office of the Attorney General, Mr. Paxton came to this body and testified before the Appropriations Subcommittee, asking the legislature to spend millions of dollars to settle his lawsuit without sharing any facts about what had happened. Millions of taxpayer dollars. $3.3 million. The General Investigating Committee retained highly qualified attorneys and investigators to learn what happened. Following months of work, including interviews with every whistleblower and numerous fact witnesses, the committee's attorneys presented detailed, fact-specific information and evidence to the committee in a public hearing. That presentation is publicly available in both video and transcript form. Most of you have taken the time and focus to carefully review that information, and for that I thank you. The evidence is substantial. It is alarming and unnerving. When we ask our attorneys and our investigators who have expert-level experience in white-collar crime and public integrity offenses, but approach this with no mind game other than to gather evidence. We ask him if the evidence showed that laws have been broken, the public trust violated, and they said unequivocally yes. The General Investigating Committee also independently reached the same conclusion and unanimously adopted the articles of impeachment that you have before you today. We take this role solemnly, seriously, and with great humility. We will not tolerate corruption, bribery, abuse of office, retaliation, and all the related charges that have been presented to you. I am confident that you cannot tolerate, let alone defend, these most serious and grave official wrongs. Now, we provided you with a detailed memo regarding the process of impeachment. So I will highlight some of those points. Impeachment is not a criminal process. The primary purpose of impeachment is to protect the state, not to punish the individual. Impeachment in the House is analogous or similar to a criminal indictment and must be followed by a trial in the Senate. A trial that every person interviewed has agreed to attend and testify under oath. The House acts similar to a grand jury. You are not being asked to decide facts or law. That is the role of the Senate. You are only deciding whether there is sufficient evidence to justify further legal proceedings. Now, a few members have voiced their concerns about process, and we've answered a lot of questions about that. References have been made regarding how impeachments unfolded in 1917 and 1975. Those matters were worked out under different rules of the House than we have today. Those matters then are different precedent than we have today. Today we have more detailed rules that makes the committee structure the workhorse and the fact-gathering guidepost for getting this done. The General Investigating Committee has followed the committee rules, the House rules, and the Constitution. All evidence was gathered in accordance with these rules and is consistent with investigations of this kind. These same members that raise concerns about process, though, have not raised concerns about the evidence, the facts. And while Mr. Paxton and his friends have spent time attacking the process, engaging in name-calling, and making political and personal threats to members of this body, he has yet to raise concerns about the evidence against him. Even in his press conference yesterday, neither Mr. Paxton nor any person with personal knowledge has denied any allegation in any article before you. Of course, they get to do that at trial in the Senate. Members, as an attorney, I have always told jurors that we judge people by what they do, not by their name or their title. I have always been a law and order public servant because I believe that having a government free of corruption in America is the only thing that separates us from a third world country. terms like integrity, honesty, and doing the right thing matter. They matter to me, and I know that they matter to you. Members, we took an oath to preserve, protect, and defend the Constitution and laws of the United States and of this state. So help us God. That's the same oath that Mr. Paxton took as Attorney General. The evidence presented to you is compelling and is more than sufficient to justify going to trial. Putting politics aside, this decision is clear. If what was expected to impeach was a full trial in the House, the Constitution would provide that. But the trial is in the Senate. You are not deciding facts or law today. You are simply deciding if this matter may proceed to trial. You are simply deciding that there are sufficient facts to go to trial. Members, I respectfully ask that you approve these articles. Send this to trial. Move adoption.
Please excuse Dr. Oliverson because of point missing the district on the motion. Mr. Goldman's objecting. Chair hears none, so ordered. The question occurs on adoption of the resolution. This is a record vote required by the Constitution. The clerk ring the bell. Shows the Speaker voting aye. Show Mr. Longoria voting aye. Mr. Murr voting aye. Show Mr. Dutton voting present, not voting. Have all members voted? There have been 121 ayes and 23 nays, 2 present, not voting, 3 absent. The resolution is adopted. The chair directs the chief clerk to notify the governor of the House's action. The chair directs the Committee on General Investigating to prepare any further resolution required by the adoption of H.R. 2377. The House will stand at ease for 15 minutes.
And then they did not stand at ease for 15 minutes. I was here watching on stream, and then about 50 minutes later, they get some movement finally, and then
the House will come to order.
Mr. Speaker.
Mr. Doorkeeper.
Mr. Speaker, I have a messenger from the Senate at the door of the House.
Admit the messenger.
Mr. Speaker, I'm directed by the Senate to inform the House that the Senate has taken the following action. The Senate has passed the following measures. HCR 114, Vassett, sponsored by Huffman, in memory of Arch Hartwell Applin Jr. HCR 121, Buckley, sponsored by Creighton, instructing the enrolling clerk of the House to make the corrections in House Bill number 1605.
Thank you, sir.
Thank you.
And that's it. That's all for the impeachment hearings. I will admit, I was pretty convinced by Murr and by Canales, even though I think Murr is a Republican. I don't know his stance yet. Texas representative Murr. I will say Canales kind of putting the roast on Smithy and Dutton was probably a bit deserved because he's a that was not very good legal talk, considering one of them was a lawyer. All right, so Murr is a Republican. That's interesting. But yeah, this whole process was Republican-led, basically. But yeah. In the Texas Constitution, the House has authority to impeach, and there's no particular rule saying they have to impeach in a particular way. So I think that works. I think there's no problems in the impeachment in form. It would be hard to articulate what they did wrong if there was something that they did wrong, because it doesn't look like they did anything wrong. With that said, I don't know what I'm going to stream tomorrow. Might just play games or work on a video. I might actually just try to work on videos tomorrow. If I do talk about anything in particular, I might talk about that U-Haul driver that crashed into Lafayette Square, because that has an interesting update that I'm going to save for another time. But yeah, with that said, I think I'm going to wrap it up here. Get started on my food early enough. And I'll figure it out later. I'm figuring out my plans. Sorry for a lot of the silence at the later end or the later portions. Just kind of looking at the feed, seeing ideas. So with all that said, remember to go to the Dragon's Treasure and use code Layman for 10% off your purchases. It is a haven for anime and tea lovers. They sell tea and now coffee. They have tea wares and a membership. If you want to start developing your own flavors, you can get a membership and then you can start buying herbs and spices. And you can still use the discount code for everything here. So remember, it's well worth it. I've been drinking the Sebastian Morning Earl Grey. It's fantastic flavored tea. I've enjoyed a lot of his flavors. I've gotten a bunch of sample packs. I can vouch with confidence. But I have a particular bias towards the cinnamon flavor. So, if you want some tea, or if you don't know if you like the tea, get a sample pack. Try it out. I promise you will not regret it. And remember to use code Layman at checkout for 10% off your purchase. I will try to restrict the amount of times I say this, because I've been called out for repeating myself too often. To everybody who watched, I thank you. Hopefully, I will see everybody else on the replay. If you liked what you saw, remember to like and subscribe on YouTube and on Rumble. It helps my metrics. It helps the growth. I will appreciate it, even if you watch on the replay. I'm going to start working on making it short form and uploading it to the main channel, cutting it down into segments and uploading it so that way it can be digestible. And I'm probably going to do shorts as well with the content. Just gonna try and like shorthand a bunch of stuff to make it more algorithmically friendly. You can go to the description down below. You'll find the Dragon's Treasure link there. You'll find the link to my channels. Remember, there is a Patreon-like thing that I use. It's called Locals. You can find me at legallayman.locals.com. And there's a blockchain, sort of cryptocurrency-esque thing that I use now called backed.buy. It's removes from any interference from like banks and governments, which is hopefully very secure. I have not gotten anything out of it yet, and I don't know much about cryptocurrency or the blockchain, so hopefully that'll work out for me. You can find me on Twitter at legallayman with 2 N's at the end of the name, and hopefully I just need some more growth on there and I can monetize my Twitter, which is fun. Hopefully I get to do that. Hopefully I get to enjoy the cool privileges of notoriety there. With all that said, I greatly appreciate you for watching. I'll see everybody else in the replay, and hopefully you guys will come to watch my shorter form videos when I can finally figure out how to get my video editor to start doing the thing I wanted to do. Hopefully I'll see you guys next time, and hang loose.